So this speak of an ideal victim. How problematic is that?
The expectation that women are going to, on the first instance, come out in public screaming, shouting, rape, help, it perhaps only happens in C grade cinema, Indian cinema. It doesn't happen in any woman's life. That you are prohibited and barred from looking at her past sexual experience or sexual history. And we are then taken into her fabricated past sexual history. And through that, her character is assassinated and her body is put on display. This search for the ideal rape victim by the Indian courts continues to give injustice.
Hello, everyone. The last few days, we've all been discussing about the judgment in the rape case against Bishop Franco. Joining me today is someone who knows the case quite well, a senior lawyer, Vrinda Grover, a feminist activist, and of course, a researcher. Vrinda, my first question to you is that last 2 or 3 days, everybody's been debating the case. Uh, a big criticism is that those who feel that this judgment was not correct, or those who feel this judgment was a step back from the criminal amendment laws, are those driven by emotions, those who believe that the survivor could not have lied. Do you think so? Do you agree with that criticism?
No, I think let us look at the evidence. What is the testimony she gives in court? How does the court appreciate the evidence? There are certain legal doctrines and legal principles on the basis of which a trial court is meant to appreciate evidence. And there are very clear guidelines now through many judgments of high courts and Supreme Courts as to how a rape survivor's testimony is to be appreciated. That, as well as the law as it stands. To my mind, this judgment is extremely flawed on legal grounds. It misreads the law. It does not take into cognizance the amendments made in 2013, as well as uses legal principles to appreciate her evidence in a very, very strange manner and discards evidence. For instance, the way language has been used. I'm now obviously only reading the English judgment. What she would have said and what the court says, for instance, when she talks, says to the other two nuns, PW3 and 4, that she was in despair and she looked gloomy because she said, I will be forced to sleep with him, referring to the bishop, the accused.
The Malayalam word used is avante bishopinte kuda kedakkan parayum.
Okay, I'm not even going to attempt to pronounce that. But so there are many cases, and this is documented in many, many rape judgments. I have done cases where a young girl from a poor family would have said to the police in Hindi, usne galat kaam kiya, means he has done something wrong, bad, he's done a bad deed with me. Or usne zabardasti ki, he forced himself. This is all phrases that the legal system completely comprehends and understands that this refers to rape. This refers to sexual assault. So for a court to say that, she's using this term and not saying the term rape is actually very odd. Very few women actually ever use the term rape because that would be artificial in a sense. Or he says she's not spoken about penile penetration, whereas she's talking about him inserting his finger into her vagina or putting his penis into her mouth. The 2013 law says this is rape. Therefore, it has nothing to do with emotion. There is the manner in which the evidence is appreciated. The court is coming from a place where the court is ignorant of the law. And the court is not cognizant of how evidence is to be appreciated.
Vrinda, so here the Malayalam word which everyone's talking about, the phrase is that she says bishop in the kuda kedakkendi varum, which means I'll have to sleep with the bishop. And the judge says that in her statement, she says, I told Anupama and Nina Rose that I will have to sleep with him, but I did not reveal to them that I have already been forced to sleep with him. So that's what the judge notes, saying that she never revealed that the act actually took place. She said
She
it could
actually
happen
has
in the future.
revealed that. So she's already revealed that to another nun, who
Hmm.
she treats as somebody with whom she confides. So I think what is happening in this case, and the only one finding that the court comes to is that yes, the accused is in a position of authority. Now that in law changes things. The law says that if rape is committed by a man who is in a position of trust and authority, then what the woman has to step into the witness box and say, I was sexually assaulted, and if that is demonstrated, that is proved, then the burden of proof actually shifts to the accused, and the accused cannot take the defense of consent. In this, the accused is not taking the defense of consent. Having come to a finding that the accused is in a position of trust and authority, the court then becomes almost oblivious to the same finding. And
Hmm.
how does this authority then play itself out in life? How does it operationalize? How does the bishop actually use that power? That I don't see anywhere reflected in the judgment as the court dealing with that issue or engaging with that issue. So having come to that finding, how does the court discard its own finding? The fact that she's asked to iron the cassock does not immediately establish who is where in the hierarchy. That she has to, I mean, surely, and she's a mother superior, she's not, the lowest in the hierarchy. How she's speaking, to whom she's speaking, how much she's narrating will have to be understood in the context of her being a nun. This cannot be, there is no set pattern of how a woman will speak. If I am sexually assaulted, or a young woman who is from a poor family is, or a maid servant is, or a nun is, or an actor is, we are on in very different contexts and locations. How much we can speak depends on that, is contingent on a host of factors. And the language I will use will also depend on that. Here is a nun in a convent saying that she is accusing a bishop. It's not just about hierarchy of status. We have to understand what is the is this to be understood in terms of having taken a vow of chastity and to live in a convent, having left a certain form of social life. What is the position and the deference that is owed to a bishop? In that circumstance, how much is she going to tell whom? What is the language she is going to use? All of that is totally absent from
Hmm.
the appreciation of evidence. So when he says she didn't tell these two, but she had already told another person some things. So she's telling different women, confidants of hers, colleagues of hers, different elements of it. And that to me sounds actually very natural and normal.
But in the case of the other person who she spoke to, which is Sister Lissy Vadakale and the prime witness in the case, the court has completely disregarded her as a witness, primarily on the grounds that the court asks the survivor confessed to you only about one rape incident, but it has happened multiple times after that. Why did she not tell you that? That's the first contention the court has. The second is a letter which Sister Lissy Vadakale wrote to her own convent saying that, look, this nun is a virgin. There is nothing like that. I only told the police because they asked me.
I think if she has told Sister Lucy about one incident,
Lissy,
and sorry,
Sister Lissy.
sorry, Sister Lizzie, if she's told about one incident and that one incident comes through clearly in the evidence, uh, rape is there. There is no provision of law which says that to convict a man, every single offense of sexual assault needs to be proved. What the court is saying is, I don't find her credible. I don't find her a reliable witness because she is. It is her sole testimony, and it's not inspiring confidence in the court. So the court is proving to us through the judgment why she is an unreliable witness. The fact that she tells Sister Lucy only about one and not the others is being held against her. Actually, the way evidence is appreciated in a rape trial is almost unique, because it's almost as though the court goes out of its way to find, okay, she said this only one thing, she didn't say the others. Well, she said the others to the others. And you can put them all together, and the story is complete and
Hmm.
reliable, and you get the full picture. There is a range of circumstances which impact women's lives, particularly if you are a nun. To say that you have been raped by a bishop, you are going to break so very many barriers, way more barriers than another woman has to when she's making a complaint of rape. We know that in this case that the women, the nuns who actually spoke out, have faced hostility, have faced ostracization, also were worried whether they will be evicted from the only home that they now know. So taking all those aspects into account, uh, to say that if you haven't told the whole story to X, it is unreliable, then the court can say just about anything. Sister Lizzie
Hmm.
actually gives an explanation in her evidence, as I see, which is recorded in the judgment, as to why she did not say, why she sent that letter. So, if there is an explanation and a reason that is being put out, and as I said before, this has to be understood in the context of a nun being making an accusation. The silence on sexual violence and sexual abuse, not only within the church, but in many, many religious institutions, is well known, well documented. It's not peculiar to this case, it's not peculiar to the church. At the same time, we do know that sexual abuse in the church has taken decades to come out. Not
Hmm.
and it's not as though women or men have been, even young boys have been able to complain about it there and then. Even in this case, it said, oh, but why did she earlier write about other things and complain about other things and not complain about rape? So, what is the complainant actually trying to do? She's trying to negotiate a space for herself where she is free from this sexual assault by the bishop. And at that time, she's writing to various authorities within the church. Doesn't that strike as a very reasonable thing that a woman who has taken the vows would want to do? How many women does any woman know who go marching off to the police, as though that is an institution, and going to go turn to the law, as though they are, there everything is going to suddenly fall in place, and you're going to have the most empathetic, sympathetic system, sensitive to your plight working? Women are aware of the realities that they're dealing with, and so they
Hmm.
are negotiating a space where she is now committed to being in the church, where she doesn't have to deal with this. And I think that is actually normal human conduct, at least from a woman's point of view. So, when courts are assessing the conduct, what is the notion that jurisprudence gives us? It says, would a reasonable person behave like this?
Hmm.
That is the notion that a court deals with. And for long, feminists have shown that a reasonable person is not necessarily the woman who is dealing with a sexual assault. A woman dealing with sexual assault, which is not, and especially by somebody who she respects, who she is obedient towards, who is superior to her, it's not something that there is any set pattern in which she's going to conduct herself or going to respond to it. So, law and courts need to learn from the lived experience of women, rather than constantly asking women to that their evidence, if it does not conform to judicial stereotypes, if it does not conform to rape myths, then her evidence is discarded and she is not speaking the truth.
Judicial stereotypes, that's actually the word. So couple of important points here. One, you're saying that when it comes to the survivor and Sister Lissy Vadakale, And of course, the rest of the case, the court is not looking at the context that this happened within the church. The court is expecting a consistency in a survivor's account. Before I move into my next question, I just want to remind everyone watching that independent media like the News Minute needs your support. So, whichever media organization that you appreciate, go become a member, subscribe to them, etc. Vrinda, my next question is very layman question. This is now the judge himself at one point says that this many letters have been written from the cardinal to others. There is, of course, this first incident which she does talk to Lissy Vadakil. Now, even if all the other incidents, the 12 incidents are discounted, even for the first incident, which, and she has written several times, even before this cousin's complaint comes, why is that the judge does not find Bishop Franco guilty at all?
Well, because he's saying she's not a reliable witness. He's
Hmm.
stringing them all together and saying, and he uses a legal principle. That's why I said in the beginning that the principles are being used to appreciate the evidence wrongly. So there is a legal principle that if you are if there is something false about your test, if you say one thing false, then the whole thing is false. This
Hmm.
is a legal principle. This legal principle has never been used in Indian judgments. There are multiple judgments of the Supreme Court which says that even if a witness is not saying is saying something that is not you if he doesn't feel like it's factually accurate or truthful, if the rest of his evidence or her evidence is correct, accurate, and truthful, then that part of the evidence, which is correct, accurate, and truthful, and stands judicial scrutiny, will be accepted, and the part that appears to be false will be discarded. And that is how evidence is read um, in
But if
many,
that's
many.
the case, my other doubt is Bishop Franco actually gives a false alibi to the court. His defense presents a false alibi. The prosecution is able to prove in front of the court is a false alibi. The court accepts it. So doesn't this legal principle apply to
Well,
Franco that
no,
if he has lied once, he has
no, I think he stands on a very different footing. He is an accused. In India, we follow a very important principle that the prosecution has to prove its case
hmm,
beyond reasonable doubt in a criminal trial, and the accused will enjoy the presumption of innocence. The accused does not have to prove anything. The accused has the right to remain silent. The entire burden, and rightly so, is on the prosecution. But if you are going to burden that prosecution with changing the manner in which evidence is read and interpreted, and say, oh, one particular aspect of this does not strike to me as true, and therefore I am going to discard the whole thing, then that is not the law that is used and applied in this country. And there are many judgments of the Supreme Court that say that. In fact, the court goes further to say that, oh, however, the reason why I'm discarding everything is because you can't separate the grain from the chaff, and again quotes a Supreme Court judgment. Again, here the court is legally wrong. The
hmm.
Supreme Court says you can, if where you cannot separate the grain from the chaff, and it leads to a new case, a new narrative, a new story coming into being, then you have to discard the entire evidence. Here, no new story is coming into being at all. No new case is getting constructed if you were to discard a portion of a testimony that the court has a right to believe. I don't think this particular incident she proves correctly, but this particular incident has been corroborated by XPW. Instead, the court discards the entire evidence,
Hmm.
and in order to show her to be an unreliable witness, actually goes many steps further, not just to say grain and chaff can't be separated, which they can in this case. Even if we were to take the point of reasoning of this court, the court, in order to then bolster its own theory, goes ahead to actually start placing on record in the judgment evidence that the person giving the statement is saying this letter is a lie, and uses that letter of the cousin to then actually create prejudice in our minds against her. and saying, oh, this woman is a nun and there seems to be something else going on in her life. And we are then taken into her fabricated past sexual history. And through that, her character is assassinated and her body is put on display by giving details which have no factual basis. But suddenly there is a pornographic detail about her anatomy that comes into the judgment which has no relevance, no bearing to the facts of the case.
In fact, this is one doubt I have. The judgment goes into detail about all the 13 acts. It just describes each one of them and about this breast examination. I've not obviously read as many judgments as you have on rape, but was that necessary on the part of this judge?
So I will differentiate and distinguish between the two insofar as the breast part is concerned. That has nothing to do with the case. It is not. It's not something that has come up vis-a-vis this accused. It is being brought in from a letter or complaint that was sent by one of her family members who herself has stepped into the witness box and said, "My letter was not true." Whatever have been the motivations, the court is alluding to the fact and bringing in, and again I'm saying, yeah, he's bringing in a false sexual history, whereas the law says that you are prohibited and barred from looking at her past sexual experience or sexual history. Here it is nobody's case that this is her past sexual history. And yet it is brought in by the court because that then makes the nun appear, oh, she is not such a virtuous lady as she's presenting herself to be. The discussion on the breast of the nun, it has nothing to do with any fact of this case or the incidents that are under inquiry and trial. What is this case about? This case is about a complaint of 13 incidents of sexual assault, all of which, as described by the complainant nun, are recognized under Section 375 as rape. Though whether these incidents have taken place or not, her anatomy is not under inquiry and definitely not pertaining to an incident which which is not even the subject matter of this case. Insofar as the other descriptions are concerned of sexual assault, see, in judgments of this kind, some descriptions, to my mind, this is my view, would have to be given. And I think that it really depends on how it is presented. And they can be written in a way that they don't become titillating, that they don't sound pornographic, and they sound as acts of violence. My personal view is that sometimes, and I'm not saying about this judgment at all, but it is perhaps important for a record, a judicial record, to speak about the violence and not just to have phrases which allude to it. Because this is experienced as violation and violence by women, but that would require the courts and the judiciary to be able to express it in a way that it conveys the violation and the violence that a woman feels of her bodily integrity.
So, for those who have not followed the case very intently, what Vrinda was talking about is a complaint which was given by a cousin of this nun, alluding to an affair between her husband and the nun. Now, in the court, the woman came and said it was an exaggerated complaint, it was a false complaint rather, and that she had some grudge. But the judge goes on to say that no, but you're a teacher, you could not have lied in the first instance. So I was listening to a interview given by the defense advocate, the senior counsel in this case. He's saying that, look, the reason why we brought up the cousin's complaint is because it is not just about the sexual history of the survivor, but the entire case is because this cousin went and complained to the church that the survivor nun had an affair with her husband, and they cooked up the rape case against Bishop Franco because he was investigating the case. So they are saying that it is not to bring out the sexual history of the nun, but it is a part and parcel of this case because they are saying the entire rape case is false and only brought up because of the cousin's complaint.
Okay, so there are two elements of it. If it is not to bring out the sexual history of the nun, the manner in which it is written and described in the judgment does violate Section 53A of the Indian Evidence Act, which says that these issues cannot be brought into the case. So, the judgment does do that. Secondly, to address the point of this being a retaliation,
Hmm.
the entire case being a retaliatory case. Now, if my recall of the facts is correct, so the first incident that she accuses him of is sometime in May of 2014.
14.
This letter is after that,
Much after.
right? This letter is not before that. Let me throw another theory. The entire letter, which the cousin today says is false. This family, the cousin's family, was persuaded and pressured by the bishop to file this false complaint within his jurisdiction so that he could exercise control over her and use this complaint to arm twist and coerce her into further silence. That's also a theory. The court may have to deal with that. Why is the court reading it in one way and not the other? Why does he think that, oh, if this woman is saying, I have refiled a false complaint, who asked her to file the false complaint is the question that should be triggered immediately. Was it
That
the bishop?
complaint was in September 2016, 2 years after the.
Why is it so implausible that maybe the accused is behind the complaint? Why is that not a plausible theory? So, actually, every time I read the case, actually, that's the theory that comes to my mind.
Hmm.
So, I don't know why the court thinks that that is not a possibility at all.
Before I move to my final question, I just want to remind people watching this about this another case which Kerala had seen, a priest called Robin who had raped a child. And people may not have forgotten that in that case, the child's own biological father at one point of time said, I raped my child. I'm responsible for the pregnancy because he was under pressure from the church to give that false statement. And then finally, it was the DNA test proved that the child's father was the priest himself. So families have gone to that extent to actually protect the church, where someone has a biological father has claimed that I am the rapist of my own child. That's the extent to which people have gone to protect the church and the priest. I just want to remind the audience that.
I'm very familiar with that case, Dhanya, because we had filed an intervention. I had
Mhm.
filed an intervention both in the Kerala High Court on behalf of some of the Christian women activists opposing when he had sought bail after conviction, saying that I
For
want for marriage, and because I want to, the child will not get any legitimacy and respect. And I am now going to give legitimacy and respect to the woman as well as the child. And then he had come, the Kerala High Court had rejected his bail, and he had come in bail to the Supreme Court, where again I had opposed his bail. And I think what we also learned from Robin's example is not just the extent to which the family can go and be pressured, but the power of the church, the clout of the
Correct.
church. The church in that local area can actually compel a father to say that he has committed rape on his own daughter. What kind of power and clout does the church wield?
True. My final question to you is something that disturbed me throughout this judgment is the judge's expectation of an ideal victim. Now, whether he found Franco guilty or not is another problem altogether. But the fact that there is a mention of a ventilated room, why did the scream was not heard is what he's trying to insinuate there. Then there are so many suggestions that she had been sending friendly emails to Franco. In fact, the same lawyers interview that I saw on a YouTube channel, he continuously mentions that she was sitting in the car with him. She went 9 days in the car with him. At one instance, she gets out of the car and she welcomes him. So this speak of an ideal victim. How problematic is that?
It's actually completely undermines and undercuts any progress we make in legal reform. And we have seen that repeatedly. This is not the first case. Unfortunately, it may not be the last. The Tarun Tejpal case comes to mind immediately. The Mahmood Faruqi case comes to mind. In each case, the
Hmm.
woman is expected to perform in a certain way. And as I mentioned earlier, where are these ideas and imagination coming in the mind of the court? These are the judicial stereotypes. These are the rape myths that the court perpetuate, and women are expected to fall and behave in this manner. Uh, the bishop is superior to her. She has to accompany him to a function. What is expected of this nun while she's still grappling with what happened? How am I going to deal with it? The expectation that women are going to, on the first instance, come out in public screaming, shouting, rape, help, it perhaps only happens in C grade Indian cinema. It doesn't happen in any woman's life.
In
I
Malayalam,
want,
it happens in A grade cinema also.
okay, well, I want us to just think about, and women will identify with this. The first time a woman experiences sexual harassment in a public space, does she start shouting and screaming? I didn't do it. You don't. You kind of cover up. Somebody in the family at, and weddings and all make some touches you inappropriately. Do you immediately bring the roof down? You don't. Men should think about their lives. Their superior has said something to them. Do they not go and stand there and continue the whole workday keeping a charade? Women are socialized to accept violence and not, and if they make this public, the shame is on them. And they have learned this over centuries. It's an
Hmm.
unlearning that we do when we approach the police and the courts. It takes huge courage and leap of unlearning. And what do courts do? The courts are saying, well, if you didn't behave like this, then you are not. This search for the ideal rape victim by the Indian courts continues to give injustice and will only prove a deterrent to women seeking justice. And it is actually totally undermining the progress we make in law. So, what we need today is a very, very urgent judicial orientation to comprehending this crime in its with all its complexities. And a failure to do that is going to lead to grave injustice.
So I'm going to wrap the discussion. So you definitely believe that this case is fit for appeal and
Oh,
there would
absolutely.
be
It's wrong in law. It's absolutely wrong in law.
the prosecution in the case is, of course, gearing up to go for an appeal. Thank you very much, Vrinda, for explaining the case to us. Thank you, everyone in the watching this. We have a series of articles we have put out in the News Minute. We're very clear about what our position is in this case, and there is no two ways about it. As I said earlier, do support independent media. Do become a member of the News Minute. Thank you.
Thank you.